Over in England, there were similar developments, with the guilds playing a key role in the social and political life of the times. Early legal persons were created to pursue activities aimed at benefiting society as a whole, or a group within society. Hospitals to treat the ill, churches to treat the soul, and municipal corporations to attend to the affairs of towns and villages. Craft and merchant guilds arose later, but would go on to become one of the main types of legal persons. The manner in which legal persons could be created had also evolved over the centuries. Whereas the Senate or the Emperor may have had the final say in ancient Rome, in medieval Europe it was generally the monarchy. Collective bodies increasingly sought to have their status as legal persons formally confirmed by the sovereign. Whereas tacit or oral approval from sovereign rulers might have sufficed in the past, the fashion of the time called for a written summary and confirmation of the collective's rights and privileges. The process behind this became known as incorporation, and the written document evidencing the official confirmation of status, the company or corporate charter. Success in obtaining a royal charter not only enhanced an organization's status, but often earned it credibility in the circles so crucial to achieving its ultimate purpose. Overall, organizations focused on economic activity such as crafts and the trade in manufactured goods grew rapidly in this period. But most of them did not pursue a purpose which was solely economic or money-driven. In fact, most companies of the period had a definite social and charitable dimension as well, generally directed at their individual communities. Forms of assistance for injured members, or for the widows and children of deceased members, were common features. That returns us to an important characteristic of companies as legal persons, the interrelationship between their underlying purpose and the nature of any privileges granted by the sovereign. Throughout the history of collectives, the status of legal person and any associated rights was a privilege, not a right.
In the background is the Charter House, which holds a special place in English company law. And it's time to find out why.
The Charter House in London is linked to one of the most important court decisions in English company law, the case of Sutton's Hospital. The dispute itself was motivated by the desire of a presumptive heir to receive property which had been granted by its benefactor to support the maintenance of a combination hospital, school, and poorhouse. The plaintiff contested the legal incorporation of the institution based upon specific technical arguments about the process necessary to create a legal person under letters patent from the king. That incorporation resulted from a testamentary gift made by Thomas Sutton for the establishment of a hospital. Summarized by a leading jurist of the day, Sir Edward Coke, it remains a cornerstone of company law in the common law world to this day.
What things are the essence of a corporation? Now it is to see what things are of the essence of a corporation. 1. Lawful authority of incorporation, and that may be by 4 means, namely by the common law, as the king himself, etc., by authority of Parliament, by the king's charter, as in this case, and by prescription. 2. The second, which is of the essence of the incorporation, are persons to be incorporated, and that in 2 manners, persons natural or bodies incorporate and political. 3. A name by which they are incorporated, as in this case, governors of the land, etc. 4. Of a place, for without a place no incorporation can be made, and here the place is the Charter House in the county of Middlesex. 5. By words sufficient in law, but not restrained to any certain legal and prescript form of words.
Before leaving the medieval period, it is helpful to do a stocktaking of the state of the law regarding legal persons at this time. Cook's summary highlights the elements of legal persons which were considered essential under the law at the time. First, lawful authority of incorporation. This could take different forms, including a formal charter or recognition of historical rights, but in any event required the approval of the sovereign. Second, the natural or legal persons to be incorporated, deemed the essence of incorporation. Third, a name by which the incorporated legal person was to be known going forward. Fourth, a place. For, in the words of Cook, "Without a place, no incorporation can be made." Fifth, words sufficient in law, though not the strict formulaic requirements as was often the case with the law of antiquity. The first 4 elements, legitimate establishment, defined participants, separate legal name, and location, were to become cornerstone requirements of the corporate entity. They describe the what, or substance, of a given corporation and remain relevant to this day.